here on campus, and I appreciate your participation at all levels. That's what makes a good contract, and I hope that you continue to do that by joining in our monthly workers meetings, participating in leadership meetings, and becoming a steward. We have an upcoming contract training. Contact Mimi about that, and she'll tell you more.
Hello, I'm Brian Caulfield. I'm the Director of Labor Relations for the University Shared Services Enterprise. That's the long name to say a spin-off of the old Chancellor's Office. And so I served as the lead negotiator for the 7 universities in the contract negotiations with SEIU. Some of you have attended the management training that I held in January, so I'm not going to have a very large role in this presentation. I just have one article to cover with you guys, but thank you for all attending.
Hi, I'm Paul McKenna. I'm the research director for SEIU Local 503, and I've sat on the higher ed bargaining team as a staff person for a number of years now, so including the last round. So let's see, we have a PowerPoint here that we're going to go through that goes over the contract changes. Mainly the contract language changes. Everybody knows what, we got COLAs, We're going to be explaining what the contract language changes were in terms of various provisions. And we're going to take turns here between SEIU and OSU and Brian in presenting these changes. So the first one is under Article 10, which is union rights, Section 6D. The change here is that we're adding investigatory meetings. So this provision of the contract says that for a new steward, they get to have a chief or senior steward accompany them the first time that they handle a grievance. That's the current language. We also added in investigatory meetings, which happen in a disciplinary situation. So in the case of an investigatory meeting, if you're the steward going in for the first time, you now get to be accompanied by a chief or senior steward. That's the change in the language on that provision. Okay, Vicky's going to do the next one.
I think I went one too many.
By the way, if folks have questions, go ahead and ask them as we go. We'll have time for Q&A at the end, but we're not going to try and make everybody wait. If you have questions as we go through a particular provision, go ahead and ask them.
So in case you all didn't hear that, Paul said shout out your question as we're going through them, even though we'll have Q&A at the end. So this change to Section 8 in Article 10 talks about all new employees shall be offered the opportunity to attend new employee orientation. So what that really means as far as a change is that if the opportunity presents itself, employees must be offered that opportunity. There were concerns that folks weren't being correctly onboarded, etc., and it wasn't known to folks that they had the opportunity to attend new employee orientation at the different institutions. Some of the 7 did a better job of providing that message than others, but this kind of releases the employee from having to go to the supervisor and say, oh, may I please, when really it's an understood agreement that yes, they may. So it changes the dynamic between the supervisor and the employee.
Okay, the next change relates to Article 10, Section 10, release time to attend meetings. Under the current contract, we have language that talks about a union representative, a classified employee, being able to attend meetings of the OUS board. Well, the OUS board doesn't exist anymore. It's been replaced by the Higher Ed Coordinating Commission, and each university has its own board of trustees. So essentially, we've just updated this language to replace references to OUS to the applicable university board or the Higher Ed Coordinating Commission. verbiage covering that. Okay. Yeah. Well, okay, so the way this new provision works, we're saying the designated employee, in other words, the employee is going to attend on behalf of the union to the commission meetings. It's when those meetings, it will be from a university in the Willamette Valley, if it's the higher ed coordinating commission, okay? So somebody doesn't get to say, I'm from Eastern Oregon and I want like 2 days off so I can attend this meeting. so those meetings are held in the valley, and the representative attending those meetings needs to be from one of the 4 Willamette Valley campuses. Okay, and then on the Board of Trustees meetings, again, we're just, the designated employee is going to work at the university's location nearest the Board of Trustees meeting location. So like in the case of OSU, this is relevant because we have employees in 36 counties, right? So if the OSU Board of Trustees is having a meeting in Corvallis, the employee attending the meeting needs to come from Corvallis.
The change in section 11 talks about submitting requests directly to the Chief Human Resources Officer or designee for union steward leave, and that's specific to attendance at the union's annual steward conference. Again, we didn't want stewards to get into the position of needing to feel as if they were confronting a supervisor when these things are already expected within the contract, and that's under the purview of a steward's rights to attend.
Okay. The next change is under Article 16, Personnel Records, Section 1E. The current language talks about materials reflecting caution, consultation, warning, or admonishment are retained for 3 years, but if requested by a maximum of 3 years. If requested by the employee in writing, the material will be removed after 2 years. The change is to change 2 years to let's see, 2 years is changed to 24 months. I don't think we actually showed the language where the change was made, but it's really just sort of a little bit of a hair splitting between 2 years and 24 months on that. But the main change here is that it now applies to any disciplinary action under Article 17. So this reference to what's maintained in your personnel file currently just it applies to materials reflecting caution, consultation, warning, or admonishment, but now any reference to a disciplinary action under Article 17 is covered. Article 17 is the discipline.
As Paul said, Article 17 is the discipline and discharge article, and the change in this area is specific to suspensions. Suspension has a different meaning for folks, and so we wanted to call out that a suspension could be with or without pay. And that is actually discipline regardless of whether it is with or without pay. So it's simply clarifying for all to have that understanding.
and assign it to that HR director. Then the HR director will meet with the union and the university. Usually it's a 2 or 3 hour phone meeting. They'll go through the case, and then that HR director will issue a decision as to whether the employer got it right or no, they didn't, and the union's grievance is sustained. We also added in there that once it's filed, the employer, the university, can request a meeting within 5 days of it being filed. And actually that language has proven very helpful in 2 situations. We had 2 grievances that have elevated to the step 3 level, one at Western and one at Southern, and the HR directors there said, well, wait a minute, I want to have a meeting with the union to talk about this even further before you assign it out to another HR director. I said, okay. They did, and those grievances were resolved at that level before it went to another HR director to sit, listen, and decide. So that one little sentence in there proved to be very helpful so far. We also worked with some procedural aspects of this. So if any of you are stewards in here and you're going to file a step 3 grievance, the contract says, please send the step 2 response with that filing, so then I can ascertain, well, what type of grievance it is. Was it timely filed pursuant to the time limits in the contract? If it's a dismissal, please send the dismissal letter with that filing, so then I can assign it out. If you fail to do it, it's not going to make your filing defective, but it just really speeds along the process. So that has also been helpful to me when assigning it out to the HR directors. What else is in there? Oh, okay. Yeah, we previously under the old contract we had we would file, or the union would file for arbitration with Federal Mediation and Conciliation Service. They would then send a list of arbitrators. The union and I, and council and I, would go through, strike names until we finally came to an agreement on an arbitrator. I said, that wastes a lot of time. You have to pay $50 for the list from FMCS. You got to pay for bios, all that. Why don't we know the arbitrators? We've worked with them. Why don't I pick one, you pick one, and then see if we can agree on the third one to have in the just listed in the contract, and we'll use those arbitrators. And we did that. And the reason for that is then those arbitrators get to know the universities, get to know the union. They know how we operate. We operate much differently from other state agencies. We're really not technically a state agency, I guess, but we're still public employees and so on and so forth. So that was the intent behind having a panel of arbitrators. Have those folks get to know us, as opposed to going from arbitrating a hospital case to a trucking case to some other industry. These 3 arbitrators are now, we filter through the arbitrators just on, again, a rotating basis. So whatever case is up next, we get that arbitrator. It's worked very well. It speeds the process along. The arbitrators know that they're on our panel. If the arbitrator that I've chosen decides that I can't do it anymore, I get to submit a couple of names to the union's council, and then he gets to choose the one of the 3 names that I send to the union council. Same thing for the union side of it. That arbitrator says, hey, I can't do it anymore, and I'm too busy, or I'm retiring. The union will send me a couple of names, and I'll choose one from that list. And then I guess, if the one that we both chose decides to go away, we have some work to do to try to figure out who should take that role. But let's see, what else have we? Yeah, so the arbitrators are arbitrator. Yeah, okay, there it is. And arbitrator Ahern is the one that we've both chosen. We've actually both worked for or have a connection to that arbitrator, so we're very familiar with him. And if we can't decide on his replacement, we'll just continue to use the FMCS. We'll just use the remaining 2 arbitrators until we've
expedited process for dismissal arbitrations, which it turned out never seemed to be workable. So we never used it in the, I don't know, 15 years it's been in the contract. And it was actually just kind of a nuisance because there was certain procedures you had to go through if you weren't going to use the expedited procedure. So we just got rid of it. So there's also, if you could go back to Article 16, I want to make a correction here. Yeah, well, there was actually, what we did was we changed 24 months to 2 years, so rather than the other way around. Again, it's sort of a, I don't know what the difference is, to tell you the truth, but I just wanted to correct that because it was stated incorrectly here. So the next one is Article 20, so Gloria is going to cover that.
Again, as we said earlier, if at any point anybody has questions about any of this, please ask. And you could even go back and ask about something that you saw before that you've been pondering upon and now suddenly are motivated to ask about. So Article 20 was a section that we got some good advances on. Persons who have bilingual capabilities in the prior contract, unless it was specifically stated in their position description that that was required for that position, they weren't offered a differential for using that particular skill, and now they are. So that's a great win. Also, another important win was the shift differential that ends up allowing for more flexibility. There are some employees that aren't eligible for overtime, and those persons had to maintain a very rigid schedule as far as coming to work at a specific time or not. And now you're allowed, with agreement with your supervisor, and I would recommend that everybody gets this in writing so that it's understood on both sides what the agreement is. You can allow for maybe the bus doesn't get to your house in time for you to be here at 8 o'clock. If that's a no, now that's a part of a flex schedule that can be agreed upon. Or maybe you have to take your child to daycare. So this is a very good win for us. And then as well, high work differentials and the code engineers are getting more of a differential. So,
One other change in that article was that temporary employees now will get the shift differential. They previously were not eligible for shift differential unless there was a specific practice at the university. So if you're a temporary employee and you work night shift hours, you're now eligible for shift differential. Vicki?
So Article 24 in insurance, previously, the employer contribution would be made for full-time employees, but we have broadened that to include 0.75 FTE or greater, who have at least 80 paid hours in a month. So of course we have to calculate hours, but we have broadened it to include the same benefits from 0.75 and above, not just 1.0 employees. And for the under 0.75, the prorated share is provided for those employees. Article 20.
Right, so if you have an appointment of 0.75 or greater as a part-time employee, you're now eligible for full-time health insurance. If you're below 0.75 on your appointment, it's status quo, it's prorated. That's the way it's been before. Okay, so on travel expenses, really the only change here was to eliminate a reference to the OUS fiscal policy manual as far as travel and mileage reimbursement and replace that with the university travel policy. So you should be able to access that on the OSU website if you have any questions about travel or state in terms of bargaining in 1996. Anybody who came to work after that did not get credited for their prior state service, in case you're scratching your head wondering about that. But there were certain provisions where if you came to work before July 1, 96, you were credited with past time, and if you came back after a break, without a 2-year break in service, that you got recredited. The basic rule going forward now is if you leave OSU service and you come back after July 1, 2015, no prior state service is going to get counted. Okay, so that's the rule going forward. It's pretty straightforward, and it's really a function of the fact that the universities are no longer state agencies. No. Okay, good question. University service, under this contract, seniority is defined as continuous service with any of the universities. And by the way, that's not just in the bargaining unit. So if you spend some time as an unclassified employee at OSU or a classified employee, that counts towards your seniority either way. Your seniority is continuous OUS service. And people who were previously credited with state service because they started a long time ago still keep that. But if you leave OSU and you come back, you're not going to get credited for prior state service. Okay? It's a little confusing, frankly. Pardon me? Missing from the summary? Oh, well, that's possible. Like,
Could you all sign in? Because we can update the summary and then email it out to this collective.
yeah. Yeah, there's some stuff that's on the summary that's not on the PowerPoint. There's some stuff that's on the PowerPoint that's not on the summary. So I guess between the two of them, hopefully it's complete. The next one we're both going to talk about a little bit. The new language in the contract says that no applications for bargaining in a position shall require applicants to disclose their criminal history. This language does not preclude the employer from conducting criminal history and background checks. So SEIU had a sort of a statewide campaign that we called the Fair Shot campaign, and one of the issues that we were advancing was what we call ban the box, which means when people are applying, basically what it says here, when people are applying for jobs, that the application itself does not require disclosure of prior convictions and that sort of thing. Not to preclude background checks, but at least to give people a chance to get in the door and be considered, as opposed to just being, have their application dumped in the round file because it has a prior conviction in there. So, anyway, there was legislation that was passed at the state level, and we also added this language to our contract. And so, anyway, that's kind of what that's all about. Vicky, you want to add to that?
This was an interesting discussion around the table because some universities actually had the box and some did not. And so this is really just about access to applying. It doesn't change how we're posting jobs or us disclosing what's required to gain the position. So if there is
next one is Article 47, and really this is the same issue that we talked about transfer sick leave. If you transfer to a different university, the current contract says you get to take 80 hours of vacation with you. This new language says that's going to depend on whether the new university is willing to accept that. And that doesn't mean you're going to lose your vacation. You'll cash it out and get it in cash if you're not able to transfer it. But you may or may not be able to transfer it and take it with you to the new university.
Okay, so position descriptions and performance evaluations. Supervisors and employees, I wanted to specifically speak to this as we have a different system than all other 6 universities do, as we programmed our eval-S system here on our campus. So this was an important factor for all universities, but because we have our own system that we programmed, I specifically wanted to speak to this. This portion of the contract talks about our requirement, and supervisors, please hear this. This is a requirement to annually evaluate a SEIU represented or classified employee. Along with that, a person can request in writing to review their position description for accuracy and understanding between the employee and the supervisor. However, we standardized this when we were able to stand up those systems that we have for reviewing PDs and have those seen by both the employee and the supervisor. So again, this is a requirement. We have systems in place, whereas the other universities actually don't, and many are still on paper in looking at these. Do you all have any questions about this?
So I just noticed that on the one-page handout, the summary document, it includes some language about layoff. This is not in any way a substantive change. It's just some housekeeping, clarifying a couple of things. So for all intents and purposes, there's no change in the layoff article. The next one is Article 61, and there were questions that the union raised about how travel time is handled when people are attending trainings. And what it came down to is there's very detailed rules from the Bureau of Labor and Industries and how travel time is supposed to be handled for purposes of, counting it as whether it counts as hours worked or not. Sometimes it does and sometimes it doesn't. It's all addressed in a lot of detail in the BOLI regulations. So basically we just wrote language into the contract saying they will do this in conformity with both state and federal rules and regulations. You were going to do 63?
Article 63 is concerning inclement weather and closures of the university is something near and dear to me because I live in the coastal range, and it's sometimes difficult traveling here. So the change here is that employees who are FLSA non-exempt
employees are exempt. For example, like a lot of the IT employees are FLSA exempt. So the rule here is that basically what we wrote into the contract is that they're going to follow federal and state regulations in terms of how they treat FLSA exempt employees. So it's not really a change because they're already, complying with those rules and regulations, but it's just nailing it down in the contract that that's what's going to govern these situations. So that's basically what we did in that article. And if anybody has any questions, we can go into more detail, but otherwise we'll just move on.
Carrie?
Yeah, okay, pyramiding of overtime means like, okay, let's say the contract says you get overtime if you work on a holiday. The contract also says you get overtime if you work over 8 hours in a day. The contract also says you get overtime if you work over 40 hours in a week, and it also says you get overtime if you work under Article 63 on a closure situation. So if you work over 8 hours in a week and over 8 hours in a day and 40 in a week and on essential closure and it's a holiday, you don't get 4 times over. You know, get time and a half times time and a half times time and a half times time and a half. If you're eligible for time and a half under one provision, you get time and a half once. You don't get, multiple times, though it would be nice. And that's not new language in the contract. Okay, so are you next?
So, this was a previous letter of agreement in the back of the contract. Mutual respect is a retitle of the same exact information, and this really is akin to a civility policy and agreement between us as members of the OSU community. So it's really important for supervisors and others that are not represented by the contract to know and understand this particular article, as you will see that it applies to managers, faculty, employees, coworkers, and supervisors. So pretty much all of us. And it is just good practice. So again, it's moving forward language and talks about our obligation to look into concerns that fall below our expectations of civility. So this is where we're having the timelines about writing a complaint, etc. These are also situations where on our campus, the concerns could be reported to the Office of Equal Opportunity and Access. I was going to say EOA. So I'm still getting used to the new name. But that could be reported to our office or to Central Human Resources. If it is reported to EOA, they would work with us on that as it is represented in the contract as well.
What is the history as to why it's not subject to grievance or arbitration?
It has always been that way from the beginning of when they put it into the contract a number of years. He was probably here for that. I was not. And I told you I'd only speak on Article 18. I'm tired of hearing from me. So you have more history on that, right?
Well, in answer to your question, this was something that the union did propose make subject to the grievance procedure, okay, and arbitration. The university didn't really want to deal with this issue in an arbitration context. They wanted to use the procedures that are more internal to the university, as opposed to having an arbitrator decide whether or not a particular supervisor had, acted in an inappropriate manner and so forth. So, we would, as the union, would like to be able to have a procedure with a little bit more teeth in it. But this procedure is available to employees. And one thing that's, I think, significant for people to take note of is where, if you can tab down one, get the right thing, sorry. a supervisor, and they don't want to confront either their supervisor personally. They have some reservations about doing it. They can go to the union steward and have the steward file a complaint on their behalf, so they're not on their own trying to deal with that difficult kind of an issue. So, you know, this procedure is available under the contract. The universities have committed to try and address these types of concerns. So I would encourage people who are having this type of issue to avail themselves of this procedure. You know, it's not arbitration, but it is a procedure that's available to remedy these types of issues, and the university has committed to you know, do what they can to address these situations.
I think it's really important to note that this letter of agreement was an agreement by SCIU and OSU initially in the contract. It wasn't until subsequent contracts that other universities joined that letter of agreement at the back of the contract. So this is a value of OSU. Others are still coming along as far as this value. However, there's crossover with existing policy and other expectations at different universities. So it was the most convenient for us to bring forward the existing LOA in its full capacity into the contract to further demonstrate that commitment. So though it's not grievable, likely behaviors that could be perceived as falling under this contract likely already fall under a different policy of the university with its own avenues of recourse. What's our next one?
Okay, this is the last one on the PowerPoint. So, as I mentioned earlier, some employees are FLSA exempt. FLSA, by the way, is the Fair Labor Standards Act. That's a federal law on overtime and other hours of work type issues, minimum wage. So, some employees are considered exempt from overtime, and it's basically administrative, professional type employees. It's defined by the regulations, federal regulations, and BOLI, the state agency, has similar regulations. So some employees are exempt, some employees are non-exempt, and sometimes people's duties change and they shift from one category to another, and so there's a need to move them from either from non-exempt to exempt or from exempt to non-exempt. Okay, so if the university believes that a position should be moved from non-exempt to exempt, there's procedure in the contract that governs how that happens. Right now, there's a window once per year during which that can happen. They have to give us notice by May 1st, and then we respond by May 20th if we have an issue, and then there's steps that follow that. The universities are feeling like that they needed to be able to do that throughout the year and not wait for this once a year window. So we agreed to amend the contract to allow those types of changes to happen throughout the year. The procedure is the same in terms of the notice periods, both for the university to notify the union and for the union to respond, etc. The only difference is that it can happen throughout the year. We also changed the procedure that goes the other way, which was where the union is raising to move a position from exempt to non-exempt. So those changes can happen throughout the year rather than being limited to once per year. I think that wraps up the PowerPoint, and I think we covered the stuff on the handout, so we're really now just open for questions. So,
There is a flexible and intermittent work
the idea here is that the language says employees who believe they are subject to such behavior, abusive behavior, should raise their concerns with an appropriate manager or supervisor as soon as possible. Okay, so if you feel comfortable confronting your supervisor about his behavior, you can do that. But if you don't feel comfortable doing that, you can go to the appropriate manager, which would presumably be that person's boss, okay? Saying, this person you supervise is acting inappropriately, you need to talk to them and get them to stop, okay? And then if you do that and nothing happens, right, or it says, in the event the employee's concerns are not addressed by such manager or supervisor within 30 days, the union, on behalf of the employee, may file a complaint with the Central Office of Human Resources. So if you've gone to your steward, you may go to your steward immediately, right, with your concerns, and your steward may be working with you from the get-go. If the concerns are not, but you don't, the procedure is not to go to the Office of Human Resources right away. You're first supposed to at least try through the supervisor or appropriate manager, okay? If that doesn't work, then the union, on behalf of the employee, can file a complaint with the Central Office of Human Resources. That way, the employee can get a little moral support having the union file on their behalf, okay, instead of just feeling like they're going it alone. Okay.
Some of the power dynamics make it so. Some of the power dynamics make it so folks are not as comfortable going to either the manager directly or the upline supervisor of the manager, and so that's the reason for the language. We would encourage everyone to resolve at the lowest possible level. That's why we encourage folks to see Sue Tyson, Brianne's here, isn't she? Back there. And so the Ombudsman office is a really good opportunity for supervisors and employees, but also employee to employee or grads, or it's open to all members of the OSU community. And hopefully that gets folks on better footing, so either can be heard through what they're experiencing as well. So that would be our hope, that we resolve at the lowest level, and this is our alternative just in case. Yes?
My question would be about the length of the contract. I see that we finally got a 4-year contract.
Yes, we
which is
did.
very good for you, but what are the openers and how often are those?
Okay, so we're open in 2017 on basically economics, salary, insurance, just a couple of other economic differentials. So, you know, we're going to be dealing with a whole lot of issues around the compensation plan in 2017, but we're not dealing with you know, all the language articles. They will not be open. The timelines are pretty much the same, and I think our first meeting is in January instead of February. Otherwise, it's the same timelines for the process, but we will only be bargaining economic issues and not all the contract language.
So just the one opener on the 4-year period?
Yeah, it's 2017, so we're sticking with the 2-year cycle on economics. You know, it's just the same as always, but on the contract language, we won't be bargaining those issues until 2019.
So the intention of this article, actually, we had a specific issue that Gloria and I worked on here at the university. And
this language was to allow people who wanted to be on a flexible schedule to be able to get the flexible schedule and without having the shift differential be a barrier. Now, a lot of people are currently on flexible work schedules because they were hired to be on a flexible work schedule. My understanding of this language was that we were really talking about future cases where somebody in the future is requesting a flexible work schedule as opposed to somebody who 10 years ago requested a flexible work schedule. I don't know whether, I think, so again, the intent is to allow people access to flexible work schedules without shift differential being a barrier, which we sort of saw as a mutual interest. Right, right. If somebody, and if somebody, yeah, so if somebody got hired on a flexible work schedule, if they applied for a position that says this position has a flexible work schedule, that this language does not apply, okay? And it also, like if your supervisor says to you and say, how would you like to be on a flexible work schedule? And you say, okay, and then you say, oh, by the way, you're on a flexible work schedule and you're not eligible for shift differential. No, it doesn't work that way. The employee has to be the one initiating the request. I would like to be on a flexible work schedule because I have some scheduling issues around childcare. Is that okay with you? Well, yes, but you know, shift differentials, you know, a problem. But under this new language, we'd say, okay, we can do that, but just so you know, you're not going to be eligible for shift differential because you know you're requesting this and we're accommodating your request. So that's the purpose of this language, okay? It's not to take away shift differential for everybody who's on a flexible work schedule.